Recheck
Checked.
YouTube live audio. YouTube live audio, okay?
Yes.
Checking Joho audio on YouTube live. Audio checked, found okay. I request our respected speaker to
Hello.
kindly start with the presentation and share the screen.
Are you looking my slides? How can I share my slides? Wait. Mic button. Pool. Arrow symbol just the pool. Showing pool. Pool. Share. Yes. Okay. Share screen. Okay. I'm sharing.
Yes, sir, you are audible. Sir, you are audible.
Next slide. Okay. Yeah. This is the details of my presentation. The recent advancement in herbal medicine in the modern health systems. With the Sai Nath University, collaboration with the Jharkhand Council of Science and Technology and Innovations, I would like to grateful to Professor S.P. Agarwal for giving me the opportunity to present my current projects. I am working on the many projects, but this is my the anti-cancerous drug developments and the some neuroprotective compounds development. So I will share my few data during my talk. This is the overview of my presentation. First, introduction, study design, materials and methods, results, the liver protective effects of the cellularins, and this is also the hepatoprotective nature of the cellularins. This is the milk threshold compounds. This is the plant extracts, and how the identification and quantification of protein by liquid chromatography, mass spectrometry analysis. And the second compounds, natural compounds, the Bacapa moneri. This is the Brahmi called common name, and the botanical name is the Bacapa moneri. The evaluation of neuroprotective therapeutics and conclusion and future direction. I would like to remind this slide I already present in the 23rd of the June 2017 in the Sai Nath University campus during my thesis defense, the modulation study of radiation responsive protein by P. hexanthrum formulations. This is the developments of the radiation used in the radiation therapy during the treatment of the cancer patients. Why we choose the study of liver cancer? Because the liver is the central metabolic organ of the body, and the hepatocellular carcinoma, this is the primary liver cancer, is the most common type of the primary liver cancers, making up about the 90% of the all cases. And this is the aesthetics of the ratio of the male is the blue, and the men and women's are the blue and pink, blue and yellow. So this is the ratio of the Hispanic populations, and this is the non-Hispanic populations of the liver cancers. And this is the non-Hispanic Asian Pacific Islands, and this is the white. And this is the non-Hispanic American Indian Alaskan. This is the down ratio of the liver cancer in the American population. Now I'm coming to the how the normal liver goes in the liver cancer. This is the pathophysiology of liver, and the healthy liver goes to the liver cancers. This is the healthy livers, and due to the excess accumulation of fat in the liver goes in the MAFLD, metabolic dysfunction association of the fatty liver disease, obesity, cholesterol, and the triglycerides, diabetics goes in the MAS and MAFLD. And then the cirrhosis, in the viral hepatitis, HBV, HCV, and liver goes in the cirrhosis, infections, and after that in the HCC, primary liver cancer. So this is the first study to demonstrate a correlation between the altered stable biomarkers of the HNRNPK and the cancer genes in the melanoma. Now I'm coming to the stress-induced liver cancers. How the stress will damage to the livers, and liver goes in the cancer, hepatocellular carcinoma. So you can see here, this is the stress affects the hypothalamus and the pituitary. This is called the hypothalamus pituitary adrenals. This is the damage and release to the stress enzyme cortisol and leptins. And the cortisol and leptins influence the oncogenes, means cancer genes, and the tumorigenesis, the growth in the tumors, and also creates the tumors. And then the liver, yeah, any organ goes in the tumorigenesis and the oncological dysfunctions. Now I'm coming to the why we choose the study of proteomic profiling, because the proteins which may provide useful information about pathogenesis of any diseases. Analysis using protein has number of advantages: easily available and easily storage, find out the new structure, mechanism and pathway analysis with the drug discovery, and therapeutics study for the treatment of the any types of the patients. How the DNA to RNA, RNA to proteins, and the many proteins make a proteomes, and all proteins is the polypeptide chain of amino acids, and this is the PTM called the post-translational modification study of CORDS in the proteomics. This is the supporting publications of the stress response proteins. We took the idea to how to identify the stress associated proteins in our study. So why you choose the silymarin? This is the natural compound, natural plant, the milk crystals, and the silymarin is the promising hepatoprotective agents in the hepatocellular carcinoma and the liver cancers. And the therapeutic potential of silymarin favorable complex derives from the milk crystals and has demonstrated hepatoprotective and anti-cancer properties. This is also used in the all several types of the liver diseases such as cirrhosis, hepatitis, and the potential use of the therapeutic agents in the hepatocellular carcinoma. And the many studies shown is the role of the silymarins in the anti-inflammatory, anti-fibrotics, and the mitigations of the stress-induced liver damage. This is our study design, how we did the experiment to find out the generate the new strategies, the role of the silymarins in the liver cancer, how the silymarin protects in the liver cancer. So first we took the three number of the samples, only silymarins. This is the cortisol. Cortisol is the stress enzymes, and the leptin is also the stress enzyme. So we treated in the three samples by cortisol and three samples by the leptins with the silymarin, and here is no any treatments. This is the controls. And after that, we isolate the protein, RNA from the cancer cell lines, SKH1, after 24-hour treatment. And then further, we did the proteomics and genomics analysis, RT-PCR analysis, and identify the number of proteins and characterization of the stress-associated novel molecular signatures in the different groups of the cortisol, leptin, and silymarin treatments compared with the controls, and then validations and the clinical correlations to the disease pathway and use for the patient treatments, and the practice used for the therapeutical study and therapeutical dose. So this is recently we published the how the proteins identification by mass spectrometry analysis. I am a lead author of these articles. This is the supporting publication, how to identify the proteins by liquid chromatography mass spectrometry analysis. This is the schematic diagrams. So how to identify the proteins by these techniques? You can see here, this is the long non-coding RNA, different types, and how the sample preparations and peptides, and then liquid chromatography mass spectrometry analysis. And this is the analysis of the identified proteins compared with the control and disease. And these are the heat maps. And also these are the validations and the correlations to the cancer genes and used for the application and validation of the clinical use of the patient treatment. So this is the sample preparation of the LCMS mass spectrometry analysis. We took the 50 microgram of the sample, trypsin digestions, and did the Orbitrap 250 explorations. This is the high throughput instrument for the identification of proteins and metabolites, lipidomes, and the transcriptomes also. So this is the supporting publication, how the therapeutics study by proteomic approach. This is the cell press papers is the showing this is the landmark of the omics approaches in the hepatocellular carcinoma suggesting proteomic substances of the patient therapy use. So we took the idea to how the role of the silymarin in the patient therapy. So this is our the concept diagram of the stress model. We have the previously stress model to how to identify the stress related proteins. This is the leptin treatment samples and this is the cortisol treatment sample. You can see here in the without treatment of the leptins and the treatment of the leptins is the significantly high. This is the MALAT1 is the cancer target genes and this is also the cortisol is significantly high. We have the previous models. Then after that goes to the identify the proteins, and we identify more than 3,000 proteins in the leptin and cortisol treatment groups of the cancer cell lines. And then after that we find out the 11 unique genes or proteins which are highly only found in the stress associated group, not in control group. So we focus on the all genes, target genes, which are significantly high in the stress associated liver cancer samples. So we validate these results. You can see here, this is the biological process of the identified proteins. We only focus on here the stress response 6.48 proteins. And these all proteins validated by the RT-PCR Western blotting analysis. And you can see here, this is the RT-PCR validation of the HNRNPK. HNRNPK is the marker of the liver cirrhosis and liver cancer. So here is the control, no any changings. Here is the only silymarin treatments, no any changing. Here is the cortisol, is the stress enzyme treatment, is the significantly high during a stress treatment. But in the silymarin treatment, the milk thresholds compound treatment is significantly down compared to the other groups. So this data is showing the silymarin is the down regulations of the leptin, cortisol, and all groups. So this is the hepatoprotectives and down the stress-associated proteins. So this is the same scenario of the leptin treatment compared to the controls. And here is the Venn diagrams of the all identified protein. We identified more than 3,975 proteins. So this is the heat map showing the significance difference between the silymarin group, control, leptin with silymarin, and cortisol with silymarin. So this is the green color is showing, this is the heat map of the identified proteins, genes, cluster genes. So this is the heat map is showing the all green colors is the down regulation, low. In the meaning of this experiment in the silymarin is the all high regulated, in the red color is showing the high up regulated genes showing the down regulation. So the effects of the stress and the cancer is the down is the treatment with the silymarin. So now I'm coming to the bioinformatics analysis of the all three main molecules such as the HNRNPK, IPO7, importatin 7 is the also a stress liver biomarker, and this is the heat shock protein HSP90B1. This is the also target genes is the marker in the cancer patients. So further we validated by these all molecules by the TCGA large patient cancer cohorts. So you can see here, this is the 50 number of the patients in the normal and compare with the 371 in the cancer tumor patients. These proteins is the significantly high compared to the controls. So this is the normal and nodal metastasis also high. And you can see here, this is the stage-wise cancer rates. This is the normal 50 number of patients and 168 in the stage 1 and stage 2 84, and this is the stage 3 82. It is significantly high, depends on the stage wise of the HNR and PK expression. Now, the same scenario of the large patient cohort of the IP-importin 7 proteins. This is the stress-induced proteins. This is the significantly high RNA expression is high in the 371 patients compared with the 50 control normal patient. The protein expression is the high of the primary tumors in the 97, and the normal 100%, normal 100 volunteers is the significantly down compared to the primary tumors. And the nodal metastasis in the significantly high in the cancer group compared with the control. So the tumor grade wise, the grade 1, grade 2, grade 3 is the significantly high compared with the normal, and the P50 mutations is significantly high compared with the controls, and this is the histological types is the high. So this is the heat shocked genes, or the RNA expression is high, protein expression is high, and the nodal metastasis is the high, and also the grade wise tumors is the high, and the P53 mutation is significantly high compared to the 50 normal patients, normal individuals compared to the cancer patients. So this is the RT-PCR analysis. Our data is showing the silymarin of the HNRN PK. Silymarin is the significantly down regulation of the all stress associated protein. You can see here, this is the cortisol treatment is significantly high, but in the silymarin treatments, the cortisol with the silymarin is the down. And here is the same scenario. And another genes here, the IPO7, in the silymarin treatments is the significantly down. And here the silymarin treatment is the significantly down compared with the other groups. Now, this is the histochemistry ISC analysis of the HNRN PK, heterogeneous ribonuclear protein K. This is the normal compared with the cancer malignants. You can see here, these are the significant differences in the nucleus, in the dark compared with the normals. You can see here all the darks in the metastasis is already happened. And the HNRNPK, heterogeneous ribonuclear proteins, is a tissue biomarkers of the hepatocellular carcinoma of the patients with cirrhosis is already reported. So in this experiment, we are showing the HNRNPK also marker of the stress-induced liver cancer, and the silymarin is protected with the down regulation of the HNRNPK and oncogenes and proteins. In the same scenario of the IP importin 7, this is also the stress marker. You can see here, this is the dark in the cancer patient compared to the normals. So now I'm coming to our current new project, the evaluation of Bacapa-Moneri, means the common name is Brahmi, and the neuroprotective therapeutics. I did the experiment and find out this is the no treatment group, and this is the Bacapa-Moneri treatment 24-hour. You can see here the significance difference because the BM, Bacapa-Moneri protectins, the neuroprotective agents, and we took the SHSY5 neuroblastoma cell lines. And this is the methods how we did the experiment to find out the BM treatments and how the BM is protecting the neuronal cells, neuronal cells and activities. This is the neuroblastoma cell lines, no any treatments. This is the Bacapa-Moneri, Brahmi treatments by BM after 24 hours. We isolated the RNA proteins in the cell lines of the both groups and analyzed the proteins genes by RT-PCR, RNA sample, Western blottings, and protein samples. And we focus the interest of these number of genes or proteins, just as the inflammatory mediators, such as the high in the Alzheimer patients, in the neural disorder, any patients, the IL, interleukins, 1 beta, tumor necrosis factor TNF alpha, leukins to IL-12, IL-13, CD48. The alls are high in the Alzheimer and neural Alzheimer, dementia, and neural disorder. Any patients with all genes proteins are significantly high, already reported at the marker of the identify and differentiate the Alzheimer's and the dementia patients and any neural disorder patient. So through this result, we are showing the IL-13s. This is the treatment of Bakapammoneri. It's a down compared with the controls. In the no any treatment, this is the high, but the BM treatment is the down. So and here the IL-12A also downs, IL-1B is significantly down, CD48, CD80, and tumor necrosis factors also down in the treatment of the Bakapammoneri group. So this data is showing the BM is the Bakapammoneri, Brahmi is the neuroprotectins in the highly upregulated genes and target genes in the Alzheimer's and the dementia neural disorder patient. So we recently published in the high impact journals around 11 impact factors, the pharmacology research. In the also the combination means any combination of the drugs, the combinations of the BCP and CPD combination is significantly down to the some in the Alzheimer patient compared to the control. So this data is showing these are the markers we recently published. These are the down regulation 147 proteins. This is the microtubule associated protein tau, and this is the BM. This is the beta amyloid also high in the Alzheimer patient. But in the treatment of the PCP CBD combination, this is the down regulation. So we can say that the combination treatments is the protecting the Alzheimer and dementia patient. So this is our conclusions. The silymarines and Bakapammoneri compounds treatment groups. I concluding in the both the natural compounds in the same slides. The silymarin, the effective down of the cortisol and leptin, a stress response protein in SK-HEPON liver cancer cell lines, and the role of the silymarines in the novel molecular pathway, offering promising strategies to the stress of the liver cancers, and the underserved population in India, US, and across the world. And the highlight the therapeutic potential of the stress-associated liver cancer while developing processings, the patient therapy for improving patient outcome for the treatments, and our aim to reduce the mortality of the high-risk group addressing the critical health challenge in Texas, USA, and the worldwide. And this is the conclusion of the Bakapammoneri projects in the Alzheimer's, dementia, and other neural disorders patients. We focus on the reducing brains against the memory enhancing effects, which help the regenerations of the neuronal tissue, and also antioxidant, anti-inflammatory, and the immune suppressive effects in the human body by the Bakapammoneri. And in future, we will validate the all data by the animal model study, and then we can put this idea for the patient treatment. I would like to acknowledge my lab members, colleagues, friends, and my directors and the dean, Dr. Kobos. And I would like to also acknowledge to my all the AACR groups. I recently present in the American Association of Cancer Research of this data. And also I would like to acknowledge Professor S.P. Agarwal to give me the opportunity to present my two projects to the silymarines and the Bakapammoneri, to the how the herbal compounds, herbal plants to protect to the livers and liver cancers, stress-induced liver cancers, and the neural disorder diseases such as the Alzheimer, dementia, and other diseases. And also, I would like to acknowledge the students, medical students in the SNU University, and the person who takes the medicines must recover twice, one from the disease and one from the medicine. William Osler. Thank you for your kind attention.
We are truly honored to have had Dr. Muhammad Shabir Hussain join us today to share such an enlightening perspective. Your ability to simplify complex concepts and engage the audience was truly remarkable, sir, and left us all with much to think about. Thank you for your time and for inspiring our community with your expertise, sir. Thank you so much.
Any questions? Any questions, please?
There are no questionnaires, sir. Thank you so much.
Okay. Thank you.
कहते हैं ज्ञान की रक्षा भी उतनी ही आवश्यक है जितनी उसकी खोज की। श्री पांडे राय, अधिवक्ता, झारखंड उच्च न्यायालय। सर बौद्धिक संपदा अधिकार एवं पेटेंट कानून के विशेषज्ञ हैं और पारंपरिक ज्ञान को कानूनी संरक्षण प्रदान करने में महत्वपूर्ण भूमिका निभाते हैं। सर, मैं आपसे अनुरोध करती हूँ कि आप कृपया मंच पर आएं और अपने विचारों से इस सम्मेलन को समृद्ध करें।
Start. Good morning, ladies and gentlemen. My greetings to all of you. With pranam to Sri Sai Nath and Ma Saraswati, I'll begin my discourse. But before I speak on the topic which has been given to me, I would like to know who all are constituting the set of audiences. I can see quite a few students, and I'm told that they belong to the Faculty of Pharmacy. Are we also having any lawyer present over here? No? All right. Ladies and gentlemen, the topic on which I am required to speak today has got three key words: law, patent, and herbal medicine. Is it fine now? Audible at the back? Thank you. I'll speak about all the three separately and then combine them together. First is, what is patent? Patent word has got two meanings, including in the field of law. Generally, when we say patent, we are talking about something which is clear, patently illegal, patently erroneous, which means clearly illegal, clearly erroneous. It doesn't require any complex argument to establish it. But here, patent is not used in that sense. In law of patent, the word patent means kind of a certificate. This word has got origin from a concept called latest patent, you must have heard about. The kings and queens in earlier era used to grant a declaration certifying something, granting the stamp of their authority over something. So it's like a monarch recognizing something. That is what is patent. And it is in that sense that patent is understood in the law of patent. It has got something to do with invention. An inventor does research, development, and comes up with a defined recognizable invention. And the reward that he gets in turn is by the government, by the ruler, by the sovereign, by the authority who controls our day-to-day affairs. The reward that he gets is this certification that he is the inventor. Excuse me. Why this reward is given? Because of the fact that he has done something which is going to prove useful for others. And that usefulness for others is the key element. In consideration what he does this, that in consideration of the patent that has been given to him, his invention is made available for use of others. Law is always about balancing of rights. What is the origin of law? It's a command of a sovereign, enforcement of which is met by physical force of the state, which means there must be a set of do's and don'ts, and there must be consequence provided for infraction, for disobedience. So like every other law, law of patent also provides for that. Why this reward is given? I said. And what is the nature of the reward? What does the patentee, in whose favor the patent is granted, gets in turn? He doesn't get the right to use it. Your baby, you are entitled to possess and use it. So right to use an invention is inherent with the producer, the manufacturer of that particular invention. It is the right to exclude others is what patent provides. So keep in mind, patent is right to exclude others from using it, from selling it, from offering it for sale, as also from making it. Patent is granted with respect to a product. A product may be an invention. Patent is also granted with respect to a process, because at times processes are also invented. Therefore, in case of a product, it is the making, using, selling, which is patented. In case of a process, making is excluded. It is the use and sale, which is excluded. Why there was a requirement to make a law in this regard? Patent has a necessary evil attached to it. The evil is that if a particular invention has been made and others are not allowed to use it, and it proves to be useful, for example, a medicine or a herbal medicine, then naturally the person having exclusive right over it will enter into overpricing. That's the natural phenomenon, except in a case where somebody is very morally high. One would naturally like to get best price. That's our human tendency. So that overpricing will go against public interest. To protect public interest, to protect the public at large from suffering overpricing, laws have been made to curb the right of patent, the right of a patentee. No right is absolute, and any right being made absolute is open to abuse, and that is where law falls into place. There is another reason why law was required to regard this. A patentee, an inventor, puts a lot of expenditure apart from his efforts. The efforts that he puts is his intellect, and that is why patent is an intellectual property. It is a property one earns. It is a property which is intangible, which is not seen from the eyes, but it is earned by use of intellect. It's an intellectual property. And the owner of that property, naturally, in order to create it, in order to reach it, and in order to maintain it further, in order to prove that it is a genuine thing, it is something which one should rely upon, undertakes a lot of expense. He will not be able to recover that expense. Therefore, patent is granted also for a larger public interest. What is that public interest? From narrower point of view, we can think that it's an individual interest which is being protected of a patentee. But if you don't grant patent and thereby you don't encourage research, you don't encourage invention, then ultimately it is going against the larger public interest. Therefore, law of patent is all about balancing right and right conflicting with each other. Patent is right to be rewarded for the expenditures that he has incurred and the intellect that he has been able to put in, and the right of public, right of the community to be able to use it. When we are talking about medicines, be it herbal medicine or otherwise, what we are talking about is public health. Our constitution, the Constitution of India, provides for one basic right. The students of law must have gone through this. There is an article, Article 21 of the Constitution, which talks about right to life. And that has been interpreted by the constitutional courts, the Supreme Court of India and high courts, to include right to health. So right to health of people is a fundamental right that has to be protected. At the same time, protecting inventions, encouraging inventions is also essential. Our constitution provides not only for rights but also duties. This is not usually advocated and propagated, but you must know that much later, after coming into force our Constitution of India in 1950, later there was an amendment brought and an article was introduced, Article 51A, 51 capital A. I mean, it was something to be introduced between Article 50 and 51, 51 and 52. Therefore, it was numbered as 51A. That provides for fundamental duties. And you will be astonished to note that humanism and encouragement of scientific temper have been put together in one clause. One of the fundamental duties of all of us is to encourage or promote scientific temper and humanism. Therefore, I find, it's my understanding, that there is a beautiful fusion in our legal system, Indian legal system, between humanism and scientific temper, which is reflected in law of patent. It puts certain restrictions against the patentee so that the public at large does not suffer, and essential medicines are not monopolized. If there is a monopolization, there are systems like compulsory licensing, which I'll come to in later course of my speech. The greatest conflict, the greatest problems are faced by the world not when there is a conflict between right and wrong. We see every day conflict between right and wrong. According to me, the greatest problem which we face is when there is a conflict between right and right. And that is what happens here. Your right to get essential medicines at reasonable price, and my right to get higher price as a reward for the invention that I have made and the research and development which I have incurred. And in all this, economy falls in place, science falls in place, and law falls in place. So law is not just a boring subject dealing with do's and don'ts. If we read it from this perspective, it becomes interesting. And even the non-lawyers would feel like studying law. And even a non-scientist would feel like knowing more of science. That is the aim of my speech today. I'll be short and crisp because much details of law will not be of much relevance to you. But the basic nuances, the basic principles, the philosophy and the policy is relevant. And that is perhaps the purpose why I have been called upon here to speak. See, the nation's sensibilities differ. When the law of patent was made in India in 1970 for the first time, there was a little history will be relevant. The first patent law in India was during the British period in 1911, the Design and Patents Act. Then we became independent for 1947. Our constitution came in 1950. First exercise started in 1948 itself. A committee was constituted headed by a judge of the Lahore High Court. And that committee gave suggestions as to what should be the reforms in the law of patent. The committee comprised of certain scientists, technical persons, and some lawyers. And the exercise was done again by constituting another committee of Justice Iyengar. First was Justice Tekchand, then Justice Iyengar. And these committee reports are still treated to be relevant today to interpret the law of patent. If there is a gray area, if there is an ambiguity, if something said in the law is open to be interpreted in two ways, then these reports help. Ultimately, 1970, the act came. A capitalist nation would not mind overpricing. They would talk about higher price being allowed, regardless of it being essential medicine or whatever. A socialist nation would talk about the public. It will talk about medicine being free, food being free, other facilities being free. India, being a mix of both, a beautiful blend, if I may say, came up with a balanced approach. Law of patent, initially made in 1970, excluded the subject of medicine which is in the nature of product. So product was made free from patenting in case of a medicine and food. That is not the situation now, because with passage of time there has been international pressures. We are signatories to international treaties. You must be reading that such and such pressure is being put by America. Even today's news speaks about some pressures being exerted by America and Indian government being accused of falling prey to it, politics apart. But the government of that day was kind enough to ensure that medicinal products are kept free from patent. Food was also kept free from patent. So far as product is concerned, process was still subjected to patent for a lesser number of years. Now, I must tell you one thing here. When patent is granted, which means the government's recognition that you are the inventor, it is for a limited period. The period is 20 years. And in certain circumstances, the patentee can suffer revocation of patent or compulsory licensing. Compulsory licensing is a very interesting topic I'll come to. This 1970 Act which came in India led to friction at international level. Those who aimed at profiteering or those who advocated for genuine protection of research and development said that India should not have so much of protection for public as against patenting. Ultimately, in 1994, an international treaty was signed at WTO, which India became signatory to. that's known as TRIPS, TRIPS. So TRIPS came into effect from 1 January 1995. India was able to negotiate a period. India was able to negotiate that it will not implement all the requirements of TRIPS and got a period of 10 years within which part-wise implementations would be made, because implementation, wherever an international treaty is entered into, that does not become law to be followed in the country automatically. That is only a guidance for interpretation of existing laws. So municipal laws, that means the local country-made laws. The local laws have to be made by competent legislature, lawmaking authority, parliament or state legislature, to adopt the provisions of international treaties. So one after another amendments came in this 1970 Act. Still, till today, it's the 1970 Act which is prevailing. And the last major amendment was 2005. Why? Because that 10-year period ended in 2005, 1995 to 2005. With the last amendment of 2005, now the patent period is 20 years and it is inclusive of the medicinal product also, which means herbal product also. So an inventor of a medicine, including a herbal medicine, is entitled to get patent based on that kind of a monopoly with respect to sale, use, etc. He will be able to give license to others to use it, to manufacture it, to sell it, and charge his price. Now, this is a general history of how patent law has come to what it is today in India. I must tell you, India has always been recognized with very high respect in the world for being compassionate to the public at large against the evils of patenting. And it has been a cause of friction between India on one hand and developed nations on the other hand. During COVID period, India advocated for complete waiver of TRIPS requirements with respect to COVID related facilities, inventions. The system operates like this. We have a controller acting as an administrator as well as a judge to deal with patent related matters. It goes without saying that he requires acumen, the scientific knowledge as well as legal knowledge. He oversees 5 offices in India. There are 5 patent offices in India. The 4 metros, Chennai, Delhi, Calcutta, Bombay, and Ahmedabad, 5th. So these are 5 places. There is a register called Register of Patents, in which there is an entry, item-wise, invention-wise, of all the details of the patent. If say you are the patentee, your name, details of the invention, everything is there. The certificate and the information about patent also contains one very important thing: complete specification of the invention. What is complete in specification? And this is filed with the application itself. You know, when we go to a court, we file a petition, and we also file annexures, which forms part of the petition. Likewise, an application for patent, for being recognized, for being granted that certificate, contains as an annexure the complete specification of the invention. Complete specification means specification which is clear enough for a skilled person in that field to perform that process, to produce it, to perform that invention without any assistance from the original inventor. So that is what is recognized. Therefore, it is not an abstract idea which is granted patent. It is always the invention, specific invention, which is performable, which is identifiable, which is granted patent. so that when it is passed on to someone, someone can use it. For example, patent for a medicine, particular medicine, a cancer medicine. A manufacturer having its own research and development lab, now all the manufacturers are big companies, corporates, should be able to carry out that exercise and manufacture it with the same efficacy, same technology. So this controller oversees everything, and to educate the persons in administration, there are two institutions in India, both located at Nagpur. The names are Patent Facilitation Cell, which is at Nagpur, and there's another one, Rajiv Gandhi National Institute of IP Management, Nagpur. Now, this controller of patent is actually not only controller of patent, it is virtually controller of IP, intellectual property. Intellectual property means patent, trademark, copyright, designs, things like that. There is a very interesting institution which has been developed by CSIR. It's very interesting. It's a matter of pride for us. It is known as Traditional Knowledge Digital Library, TKDL. We had a gentleman called Professor Masalkar, who was heading CSIR. Sitting in his office, he found one day that two residents in America, perhaps they were Indians origin scientists residing in America, they got turmeric patented, haldi. Now imagine, our turmeric was shown as an invention by those two gentlemen there. Invention for what? Invention for healing properties, healing of wounds. So our scientists sitting at CSIR saw this, they felt offended. They rushed to America, to the patent office over there, filed their objection with evidence, with our older literature, and showed that for 1,000 years, our country has been using haldi, turmeric, for healing of wounds. So there is nothing new that has been invented by these two gentlemen. Eventually, that patent was revoked, cancelled. Likewise, in European Union, there was a patent obtained for neem for healing kind of fungus in plants. So again, some NGOs from India took offense to it, and Government of India, and they filed their objection and got it cancelled. These are challenges. We face challenges of biopiracy. We face challenges because we are possessor of very old, very ancient knowledge. So TKDL, the Traditional Knowledge Digital Library, was built by CSIR. What for? They said that we will have a digital library which will store informations with regard to all the old inventions which we have already done, which our sages have already done, which Rishi Shushruta perhaps must have done, and Dhanvantri must have done. So, hundreds and thousands of such things which are available with us have been incorporated there in that library, so that anywhere in the world, in their local jurisdiction, if some application for patent is filed, then the patent granting authority can have access to that digital library and see whether in India this invention already exists, and refuse. And perhaps more than 200 applications have been rejected on the basis of this TKDL so far worldwide. This is an illustration of how important administration of patent is. There is a judicial side of it also, which I'll speak at the end of my discourse. There is an adjudication system. You can, from common sense approach, you can understand. See, understanding law is a common sense approach, and I invite you to apply that. There's nothing, there's no rocket science here. Naturally, when somebody asks for patent, his application will either be rejected or granted. So there will be appeal as against that. You need some adjudicator. If a patent has been granted, there may be challenges by subsequent discoverers that it was wrongly granted. Then if certain conditions are put, there may be put to challenges. If there is infringement in the sense violation. If I am the patentee and without my permission, without my license, if somebody is using it, selling it, then there will be an adjudication mechanism. So here, the first authority usually, most of the things, is that controller. There was a system of having tribunals in between, which has been scrapped now. And now most of the appellate powers, challenge hearing powers are conferred with the high courts. But I must confess, the matters are not much here. We don't have much of experience here. My friend called me an expert of patent law, which may not be an accurate description of mine. We don't get opportunity to earn that expertise. I can get knowledge by reading, but we don't have experience. In my 27 years of career as a lawyer so far, I have perhaps dealt with 1 or 2 cases in which law of patent was involved. That too, when violation of Patent Act was wrongly attributed to somebody for his say copyright violation or trademark violation. And I argued that, look here, by plain reading of patent law, the case is not made out and got relief. So not, the technical aspect of law of patent has not actually been practiced over here. We don't get much of it. Now I'll shift to the basic features of the law of patent with special emphasis upon medicine and herbal medicine. The Act, like every other legislation, has got an opening chapter of definition. And then there are certain sections which are to be read with that definition. Definition in any act is provided so that the main provisions can be read and understood properly, in what sense a particular word has been used. So the word patent has been defined as patent means a patent. It's a circular definition. It doesn't take us to correct conclusion, in fact. Patent means a patent for any invention granted under this act. So a patent has to be granted under this act. So we have to read the whole act to understand how it is granted and what is granted. But it is clear, one thing is clear, that patent is for an invention as per the lawmakers. Now invention has been defined, and that's very important. So just reference to 2-3 sections will be enough. 2-3 provisions would be enough for you to understand the topic of the day. Invention means, and please notice the emphasis which I am laying on few key words in the definition. Invention means a new product or process. So new is the first keyword. There must be novelty. And it is this novelty which is subject matter of struggle in courts and before authorities. I claim that this is something new, and you say there is nothing new. It's old wine in the new bottle. You have just put a flavor. There's nothing new. It's a medicine with just little amount of different proportion. Say, it's just paracetamol. With instead of 350 mg, it is 500 mg. So it is actually not a new product, but a slight modification. This is where the lawyers get opportunity to argue one way or the other. Our job is never finished. Our employment is always taken care of by God. So the definition is, it means a new product or process. I said that there are 2 things for which patent is granted: product and process. A new product or process involving an inventive step. So your common sense approach comes here. Inventive step. What does it mean? It is qualified by an expression. a new product or process involving an inventive step. And what is an inventive step has been defined elsewhere. I'll come to that. And third requirement is novelty was the first requirement. Second is inventive step. And third is it must be capable of industrial application. So law of patent, please keep in mind, medicines, what we say is Gharulu medicines, that's one thing. But that identity must be attributable as an industrial application. The patent must be capable of, giving rise to some production process and, that kind of an element of involvement of industry. What is relevant for us today is the first two elements, inventive step and novelty, new. Inventive step has been defined. What is inventive step? Inventive step means a feature of an invention. So again, common sense approach you have to understand. A feature of an invention that involves technical advance. You can understand this from the perspective of a research or a lab activity. So an inventive step has to be there for grant of patent, which means there must have been feature of an invention, that means technical advancement, not just modification. And while one can argue that modification is not an advancement, somebody else may opine that it is still an advancement. So case laws come, views change, opinions of two judges may differ, arguments of two lawyers may differ, and of course views of the experts, the scientists may differ. Somebody may say that a medicine is an invention because it is completely new, because it has got completely new therapeutic effect, healing effect, treatment effect. Somebody may say that another medicine which has got less side effects than the previous one is also an invention. So why not patent be granted to that? Now all these arguments become subject matter of court cases. And we enter into an interesting arena, but all that can't be discussed today in this short period of time. For example, Madras High Court refused patent to a product which was comprising of kind of goita, cow dung, cow ghee, cow milk. They said all this is not innovation, everything is known to us. A mixture of all these three cow products and neem and something else. So this neem has got a therapeutic effect. Neem has also got some effect, known effect. What is that? Disinfectant. So the producer projected as if it is something which will be a one-time lamp, which will also have an disinfectant effect. Idea is good, but the patenting was refused by the court on the ground that there is nothing. It's not an innovation. It does not contain an innovative step. It's not an that element of novelty is missing. So this is one part of law of patent which is relevant for our medicine aspect. You as a scientist, as a researcher, should come up with something new, and it must be involving some inventive step, having technical advancement. Another very important part of law of patent is there are certain things which have been defined as non-inventions. It has been kind of clarified. Something which does not partake the character of an invention, and something which is otherwise an invention in yours understanding and my understanding, but the lawmakers say it will not be treated as invention. Few of them are relevant. At least 4 of them are very relevant. There are many clauses in section 3 of Patent Act. One of them is clause D, which has become subject matter of a lot of controversies and adjudication processes. Section 3 clause D. So see, section 3 talks about exclusion. When patent will not be granted, when a particular claimed invention should be treated as non-invention. So they said one is, just pay attention to the language. Mere discovery of a new form of a known substance. Mere discovery of a new form of a known substance. So element of novelty is there, but the substance is already known. You're just coming up with a new form. So one was mere discovery of a new form. The escape route is there. That there may be enhancement of its known efficiency. In that case, it will be treated as an invention. Right? They, one of the very leading judgments of the Supreme Court is when they refused patent to a company which had come up with a cancer drug, and the patenting authority said that there is nothing new. It's only new, the known substance in the new form. There is another clause which is very important, and which is actually what is hitting those who are proposing to get patents over herbal medicines. The language I'll place before you, which is clause P. Clause P of section 3 says an invention. So it agrees that it's an invention, which in effect is traditional knowledge. So problem is, when it is a traditional knowledge, there is nothing new. It's known. So invention, which in effect is traditional knowledge, in effect. So pretext will not do. Camouflage will not do. In effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components. Okay? So this is where those who want patent over herbal medicines will have problems, and those who want that there should not be patenting so that the herbal medicines remain available at cheaper prices will be happy. These are two important things. I would like to cut short my my talk, because the next speaker, I'm told, is waiting. And if you have any question, you can put to me, which I'll be happy to answer. But before that, just one line. As I said, there is a complete system of revocation of patent. There is a complete system of infringement being treated with, if there is an infringement, injunction to stop the infringer, damages to compensate somebody's right which has been infringed, and compulsory patent. I'll just like to say one line about it. Compulsory patent is like a policy of the state. If the government feels, or the patenting authority feels, that compulsory licensing should be allowed in favor of somebody else, then regardless of the patent being existing in one or other person's favor, there is a compulsory licensing. He gets a small amount of royalty. And in the best case available in country, best example is Bayer. Bayer is a US based company. They had come up with a cancer drug which was coming at a cost of 2.5 lakhs for a week or for a month, for a particular period. So compulsory licensing was imposed in India, and the license was granted in favor of Novartis perhaps, and the medicine's cost came to a few thousands, and Bayer was given 6% royalty. That's compulsory licensing. India is criticized by the developed world for adopting compulsory licensing frequently, for being slow in grant of patents. And there is also a provision that for research and development and for larger public interest, government may curb the patent period. So this is what we can understand from our understanding of our country. There is nothing that is very, very complicated. I invite you to read this law in light of whatever I have said. You will find it very, very friendly to you now. I thank you very much. Thank you, the patient listeners, the management of the university, and Suman Srivastava ji for catching hold of me to speak on this. It was a learning opportunity. Thank you very much. Very good day.
Thank you so much, sir, for gracing the occasion with your valuable insights. We are grateful for your presence in Sai Nath University.
जब शब्द थम जाए नृत्य बोलता है, ताल में बंधा हर भाव संस्कृति खोलता है. We present a welcome dance reflecting our rich cultural heritage and spirit of hospitality. For this, I would like to invite Supriya of Agriculture Department.
गणनायकाय गणदैवताय गणाध्यक्षाय धीमहि गुणशरीराय गुणमण्डिताय गुणेशानाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि
सर्वांगी सुंदर उदिशेंदुराची कंठी झळके मान मुक्ता फळाची जय देव जय देव जय देव जय देव जय मंगल मूर्ती हो श्री मंगल मूर्ती दर्शन मागे मन कामना पूर्ती जय देव जय देव